You're listening to an African Elements top news story for June 30th, 2025. Please visit our website at africanelements.org for more daily news. Mississippi's DEI ban faces legal challenge. By Darius Spearman. A federal lawsuit has been filed against Mississippi's new Anti-Diversity, Equity, and Inclusion (DEI) law, House Bill 1193. This legal challenge argues that the law violates fundamental rights protected by the First and 14th Amendments. The lawsuit was brought by a group of organizations, including the American Civil Liberties Union, ACLU, against the governing boards of Mississippi's public schools and institutions. The plaintiffs in this case argue that the law's unclear language restricts the speech of educators and students, infringing upon their First and 14th Amendment rights. They are seeking a temporary restraining order to prevent the law from being enforced. This request highlights serious concerns about the law's potential impact on education across the state. The ACLU's lawyers have asked federal Judge Henry Wingate to halt the enforcement of the ban on state boards overseeing K-12 schools and public universities. The state's Assistant Attorney General, Rex Shannon, representing the targeted state boards, argued against granting the temporary restraining order. He stated that doing so would infringe upon the state's sovereignty. Judge Wingate pressed Shannon to explain the specific harms the state would face if the order were granted. However, Shannon indicated he did not have enough time before the case to provide those details. Judge Wingate is expected to decide on the restraining order soon. House Bill 1193, signed into law on April 14th, prohibits public schools, state-accredited non-public schools, and state-supported institutions of higher learning from creating, teaching, or promoting DEI programs. This law is scheduled to take effect on July 1st. The bill also bans the requirement of diversity statements or training in hiring, admission, and employment processes at educational institutions. The law explicitly prohibits the use of diversity statements and training in hiring, admissions, and employment practices at state institutions of higher learning. It includes a provision allowing individuals to file complaints regarding violations. This process involves an investigation and potential resolution by the educational institutions themselves. Should a school receive 2 violations, the state could withhold funds until the issues are corrected. Diversity, equity, and inclusion (DEI) initiatives in education encompass programs and policies designed to create a more diverse student body and faculty, ensure fair opportunities for all, and foster an inclusive school environment. Many people who view DEI as something to demonize do not fully understand the wide range of services these offices provide, according to Paulette Granberry Russell, president of the National Association of Diversity Officers in Higher Education. For example, the Women's Center at the University of Cincinnati offers training on salary negotiation, programs addressing eating disorders and body image, support for survivors of sexual violence, and access to emergency contraception. These initiatives aim to address historical disadvantages and create spaces where people from all backgrounds feel welcome and have equal chances to succeed. Even fields like dermatology advocate for DEI in education and training. This helps healthcare providers avoid misdiagnosing and mistreating diverse patients. The lawsuit against Mississippi's DEI ban claims the law is unconstitutionally vague. This legal argument touches upon crucial protections under the First and 14th Amendments. The First Amendment protects freedom of speech, which includes academic discussion and expression related to diversity. If DEI bans restrict these conversations, they could violate this fundamental right. The 14th Amendment's Equal Protection Clause ensures that states cannot deny any person equal protection under the law. If DEI bans are seen as creating unequal opportunities or treatment based on identity, they could be challenged under this clause. The vagueness of the law itself is a significant legal concern. Laws must be clear enough for people to understand what is prohibited. A group of higher education associations previously sued President Donald Trump, arguing that his efforts to eliminate DEI initiatives through executive orders were unconstitutionally vague. The lawsuit claims the law's language is vague and contradictory. While specific examples from House Bill 1193 are not detailed, similar legislation in other states shows that the ambiguity lies in how broadly terms like diversity, equity, and inclusion are defined. It also leaves unclear what specific actions or discussions are prohibited. This vagueness can cause uncertainty for educators and students, potentially leading them to self-censor or dismantle programs out of fear of punishment, even if those programs are not explicitly banned. Opponents of the law argue that it is ridiculous and will significantly change education in Mississippi. One critic stated, "It's one of the most ridiculous things to come out of the legislature in a long time, and that's saying something," adding, "It's really going to alter education as we know it in Mississippi." The lawsuit alleges that traditional literary works and discussions on historical and social issues could be banned. This is because much of American and global history involves divisive concepts. For example, if a teacher states, "Slavery was bad," or "Mississippi has a shameful history of lynching," and a child's parents disagree, the law's vagueness could allow them to file a lawsuit claiming a violation of the DEI ban. This raises the question of whether schools will stop teaching about historical horrors simply because they might offend some people. A bill in Texas, for instance, would ban classroom instruction and student clubs based on gender identity and sexual orientation. In Kentucky, offices and departments have already begun to dismantle courses, programming, and content due to fear of retribution from proposed legislation. This suggests that discussions on historical and social issues, particularly those related to identity, may be limited. The implementation of these restrictions would likely involve schools reviewing and potentially changing their existing curricula and extracurricular activities to avoid perceived violations. Opponents of anti-DEI legislation express concerns about significant negative impacts on education and society. They argue that such bans threaten program accreditation in various fields, including healthcare. In these fields, DEI in training is crucial for avoiding misdiagnosis and mistreatment of diverse patients. Without DEI in such training, the citizens of Mississippi could be at risk. Critics also highlight that these laws can lead to the dismantling of valuable programs and content out of fear. They also state that these laws are unconstitutionally vague. Furthermore, the elimination of DEI offices can remove services that support student well-being, such as those addressing mental health, sexual violence, and financial literacy. On the other hand, some proponents of anti-DEI legislation argue that it leads to increased efficiency. They argue that DEI programs have not proven to be efficient or productive uses of funds. Supporters of similar legislation in Texas have argued that DEI policies in schools are ineffective and wasteful. Proponents of Kentucky's HB 4 frame DEI initiatives as discriminatory, asserting that they only benefit certain groups and can lead to the hiring and recruitment of underqualified individuals and students. The underlying philosophy for some proponents is to restore colorblind equality in public institutions. Model legislation proposed by the Manhattan Institute, a conservative public policy organization, advocates to abolish DEI bureaucracies and restore colorblind equality in public universities. While specific data supporting claims of inefficiency or wastefulness is not always presented, these arguments form the core of their rationale for banning DEI. Mississippi's DEI ban is part of a larger national trend. States such as Texas and West Virginia have passed similar laws banning DEI in K-12 and post-secondary education. Ohio Senate Bill 1, also known as the Enact Advance Ohio Higher Education Act, aims to prohibit the use of diversity, equity, and inclusion in higher education. Many colleges have already begun phasing out their DEI initiatives. This is a result of a Dear Colleague letter sent by the Department of Education. This letter threatened to withhold federal funding from schools believed to have DEI initiatives and programs. State Senator Brandon Creighton, who authored the 2023 DEI ban in Texas, warned higher education leaders in March 2025 that non-compliance could result in the loss of millions in state funding. The language in bills targeting universities and K-12 schools often comes from model legislation proposed by the Manhattan Institute. This conservative public policy organization advocates to abolish DEI bureaucracies and restore colorblind equality in public universities. The broader public and educator community's response to these laws extends beyond lawsuits. It includes deep concern about the future of inclusive education. Democratic Representative Bryant Clark, whose father, Robert Clark, was the first black Mississippian elected to the state legislature since the 1800s, argued that Mississippi's DEI ban was unnecessary. He found it particularly offensive given the state's dark history in its treatment of black people. Clark stated during the debate, "We are better than this, and all of you know that we don't need this with Mississippi's history." He added, "We should be the ones that say, listen, we may be from Mississippi, we may have a dark past, but you know what? We're going to be the first to stand up this time and say there is nothing wrong with DEI." The lawsuit against House Bill 1193 represents a critical moment for education and civil rights in Mississippi. The outcome of this legal challenge could set a precedent for other states considering or implementing similar anti-DEI legislation. The fight for diversity, equity, and inclusion remains a vital component in ensuring that all students, regardless of their background, have the opportunity to learn, grow, and thrive in an environment that respects their full humanity. Copyright African Elements.